Hello, my name's Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. In just 15 minutes we'll keep you abreast of the big commercial legal news stories. So grab a cup of tea, relax and allow us to keep you effortlessly updated with the information that your business can't afford to miss. First up, employment. The big story of the month undoubtedly is the holiday pay saga. The news broke on the 4th of November that the Employment Appeals Tribunal, the EAT, had answered the question of what constitutes normal remuneration for holiday pay purposes. The key issue being whether holiday pay should include overtime that an employee normally earns, or whether the employee is only entitled to basic pay for holiday periods. The EAT held that the employers must pay normal remuneration for holiday, and that includes regular overtime, regardless of whether it is guaranteed or not. But this only applies to the first 4 weeks of holiday. With regard to claims for holidays already taken, aside from very recent holidays, we believe that's unlikely, although the door is not completely shut. Doubtless there will be a test case. Naturally, with any such significant change in the law, the first task will be to consider the financial impact. And once that's done, we recommend that employers review their current contracts and policies and consider any knock-on effects. Perhaps the most obvious knock-on effect will be the impact on pensions. Finally, and just to flag, we may not have heard the end of this story, as the door has been left open for an appeal. Intellectual property and website blocking orders. The Richmond Group has obtained a website blocking order against 5 internet service providers. Richmond, who is the owner of luxury brands including Cartier and Montblanc, obtained the order to obligate several internet service providers to block access to websites selling counterfeit goods. It's an important case, as until now there's been a confusion about whether this right exists for trademark holders, as the relevant legislation only makes specific reference to copyright. Given the inherent difficulties of pursuing invasive counterfeiters, this case has opened up a new and arguably more effective weapon to tackle trademark infringements. Marks & Spencer's wins again on the Google AdWords debate. If you're an avid follower of intellectual property news, you'll probably be bored with reading about the Marks & Spencer's and Interflora AdWords spat. It's been running since 2008, has been to the Court of Appeal on 3 occasions, and each time Marks & Spencer's has been successful. To recap, the case concerns Marks & Spencer's purchase of the Google AdWord Interflora. When a user types in Interflora, you get a Marks & Spencer's advert in the Google sponsored links. Interflora is a trademark owned by Interflora, the network of businesses that deliver flowers. Marks & Spencer's use of the trademark is invisible, in that the word Interflora has never appeared in any of the adverts. As Marks & Spencer's is not part of the Interflora's network, Interflora has challenged this use of its trademark, claiming that Marks & Spencer's is free riding on its brand. The most recent Court of Appeal appearance in November is probably the most important, as a retrial has been ordered. So where does the law stand today on AdWords? Well, although not conclusive, there have been a string of cases that suggest that the use of another party's trademark as a keyword is permitted, provided the advert does not mislead the user into believing that goods and services are those of the trademark owner. Data protection and wearable technology. A recent collaboration between Intel and the fashion designers to create a smart bracelet seems to have sparked discussions about the legal issues of wearable technology. Wearable technology includes things like smartwatches, fitness trackers and satellite navigation units. Such devices collect substantial data about the user and often automatically upload the information to the cloud. One of the biggest threats to this technology is privacy issues, and companies embarking on such initiatives must get all the relevant issues, such as who is controlling the data and what has been made clear to the user, sorted at the outset. Technology of this nature does not create new legal issues, but it does show how they create added complexity. A criminal conviction for a director that illegally accessed a customer database. A company director has been fined £500 and given a criminal conviction for illegally accessing one of Everything Everywhere's customer databases. Matthew Devlin, a director of a telephone services company, impersonated the company's security team in order to gain access to the customer database. He then used the data to target customers with services offered by his business. Organisations must stop SQL injections. The ICO has warned that organisations must take actions to stop SQL injections. Like us, you may have no idea what that is, but we can explain the impact. The warning issued by the ICO in November follows a hotel booking website operated by Worldview Limited that had its website hacked and full payment card details of almost 4,000 customers stolen. The website was encrypted, but the decryption key was stored with the data, making it vulnerable to attack. Aside from reputation and compensation claims from customers, the ICO is now issuing significant fines. In this case, the ICO stated it would have fined Worldview £75,000, but was required to consider the impact the penalty would have on the company's financial situation. Instead, the company was fined £7,500. If, like most businesses, your website is hosted by a third party, it's imperative that the hosting company is under a contractual obligation to meet the latest security standards. That said, our advice first and foremost is to undertake robust due diligence on your business partners. In this case, in cases where your website hosting company will store data, ensuring it is compliant with ICO 27002 is a good first step. There is also a standard specifically for payment card data called the Payment Card Industry Data Security Standard. Further information on data security for SMEs has been developed by the government's Information Assurance and Cybersecurity Programme in the form of an e-training programme. We've included a link in the PDF version of this newscast. The ICO is working with Which on nuisance calls. In our bulletin last month, you may recall that we reported the case of Ofcom against Aegis Retail for making abandoned calls. I'm sure we've all experienced such calls. The phone rings, but when you pick up the phone, there is no one there. This is usually the result of automated calling systems designed to keep all of the call handlers busy, but sometimes they're too busy to speak with you. The ICO has now announced that it's part of a task force with the consumer group Which to look at new ways to tackle the problem of nuisance calls and spam texts. The task force is currently considering how to improve the ways companies obtain and record consent and how to reduce the unfair and unlawful trade in personal data for marketing purposes. Instead of suggesting changes to the law, the task force's recommendation will focus on practical steps which businesses should take to improve their marketing practices. A part of this work last month, the task force held a session with Parliament, with MPs, business and consumer representatives. A report will be published by the government on the 8th of December with these recommendations, and we'll be keeping an eye on the developments and we'll keep you updated. Advertising and price wars. Sainsbury's and Tesco's price war recently had the bar raised with a judicial review application. Sainsbury's challenged Tesco's claim that you won't lose out on big brands, own label or fresh food, stating it was misleading as important attributes such as ethics and provenance had not been taken into account. The ASA, however, held that the same needs or purpose test under the CAP code had been met as food was interchangeable and intended for the same purpose. Sainsbury's took the matter to an independent review, but was rejected, albeit sympathetically. The independent reviewer stated, Sainsbury's can be right that non-price elements of products are material to many customers, but that does not mean that the ASA is wrong to conclude that they were not material or essential or indeed important to this particular comparison. Undeterred, Sainsbury's made a judicial review application to the High Court, but was also rejected. The recent case of Data Resource Limited v Data Services Limited highlights the need for detailed clauses when reserving a right to inspect the other party's compliance with the contract. In this case, the claimant had licensed the use of the database to the defendant. The claimant reserved a right in the contract to enter the defendant's premises to check that it was complying with the terms of the licences. The court held, however, that the licence was defective as it did not detail its rights once it had gained access to the premises. It had not, for example, said whether it had unlimited inspection rights and whether it could look through every file. Whilst the courts are often willing to fill the gaps, this case demonstrates they are not willing to rewrite contracts to find the logical position. Turning to another case of Polypearl Limited v Eon Energy Solutions that emphasises the need for the clear drafting. We'll start with a quiz. Imagine you're a supplier and you want to exclude liability for loss of profits and the contract includes the following clause. Neither party will be liable to the other for any indirect or consequential loss, and then open brackets, both of which include without limitation loss of profit, loss of business, and close brackets, howsoever caused. Does that cover it? My guess is that you will all spot the problem given time to study it, but perhaps you'll also share my view that it would be easy with a quick read to believe that the clause does what you require. This certainly seems to have been Eon's conclusion when the contract was negotiated. Given the explanatory wording in the brackets that followed the words indirect or consequential loss, the court held that it did not exclude direct losses of profits. This was a bitter blow to Eon, as the loss of profit claims fell squarely in the direct losses camp. Claiming in-house lawyers' costs. A recent Employment Appeals Tribunal case, LADAC v DRC Locums Limited, confirmed that an in-house lawyer's cost can be recovered for litigation in a tribunal. In this case, LADAC had argued the employment tribunal rules did not permit such recovery, but this received a sharp rebuff by His Honour Judge Richardson, who stated, "To my mind it is plain that the words fees, charges, disbursements and expenses are not to be read restrictively." Turning to the question of what costs can the in-house lawyer claim, the civil courts have usually taken a pragmatic approach and looked at the cost of employing the lawyer. Inevitably, however, in the event that a company wants to recover such costs, it will have to show detailed records of the time that the lawyer spent on the matter, and only legal work, not administrative work, will be claimable. The CMA has confirmed it will open an in-depth investigation into the markets for SME retail banking and the supply of personal accounts. The CMA has highlighted a number of concerns, including low levels of customer switching banks, complexity of making comparisons between banks' offerings, the ability or lack of ability for smaller and new providers to develop their businesses, and very little movement in the market shares of the 4 largest banks. The investigation is expected to last for 18 months. The CMA has a wide discretion to the remedies that it can implement. Thanks for joining us for this month's Commercial Law Update. The video and podcast are available to download on the LexisNexis in-house blog page, together with the original report. The website details of LexisNexis and Radius Law will be shown on your screen shortly. Until next time, thank you and goodbye.